Hello friends, very warm welcome to my business law channel. Till now I have covered 4 chapters in this business law paper, and today I am going to start chapter number 5. Regarding this chapter number 5, I'll be making 4 videos. 4 video classes. In 4 video classes I will cover the entire chapter, which is chapter number 5, entitled Free Consent. So in today's class, friends, I'm going to take up the definition of consent, and then I'll take up features of consent, features of coercion. Now, definition of consent. You all know, friends, the term consent has been defined under section 13. 2 or more persons, they are said to consent when they agree upon the same thing in the same sense. And now X owns 2 cars. One is Honda City and other is SX4. X intends to sell one of the 2 cars to Y at a certain price, but he does not specify. Now Y is thinking of buying his Honda City car, and there is no consent here as both the parties are having different car in their mind. So friends, there is no consent here because both the parties are not agreeing upon the same thing in the same sense. Now friends, I would like to explain the meaning of free consent. Because one of the essentials of valid contract is that consent should always be free one. And now the question arises, what is the meaning of free consent? Consent is said to be free when it is not caused or obtained by coercion as per section 15, undue influence as per section 16, fraud as per section 17, misrepresentation as per section 18, and then mistake as per section 20 to 22. Now the question arises, what is the impact of no free consent? Let us presume if the consent is not free one, it has been caused by coercion, undue influence, fraud or misrepresentation, then in that case the contract becomes voidable. So there is no free consent in that case. If the contract has been, consent has been affected by any one of the 4 elements, coercion, undue influence, fraud and misrepresentation, then in that case the resulting agreement becomes voidable contract. Voidable contract provides 2 options to the party. One is affirmation, second is cancellation. So it is party's choice which of the 2 options the party would like to exercise. Now Salmond has put it, friends. Salmond describes no consent as error in consensus and no free consent as error in causa. And now in my lecture class, friends, I would like to define the term coercion. Coercion is the term, friends, which has been defined under section 15. When a person is forced to give his consent, then coercion is said to be employed. It means a person is not going to willing to give his consent, but he is forced. He has been compelled by the other person to give his consent. Then we say coercion has been employed or exercised. Now, section 15 provides coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code, or unlawful detaining or threatening to detain any property to the prejudice of any person, whatever, with the intention of causing any person to enter into an agreement. So friends, explanation to section 15 states that it is immaterial whether the Indian Penal Code is or not in force in the place where coercion is employed. So it is not necessary the place where coercion is employed, the IPC must be in force. It may be in force or may not be in force. So all the points which are there in the definition, which is given under section 15, they will be clear when I'll take up the heading features of coercion. So now friends, I'm going to take up the heading features of coercion. Then all the points will be clear to you which are there in the definition which is provided under section 15. So the very first point is committing or threatening to commit any act forbidden by IPC. IPC stands for Indian Penal Code. So the very first line is committing or threatening to commit any act forbidden by IPC. Now either the act is committed which is prohibited by under IPC, or threat is given to commit the act which is forbidden by IPC. There's a very important case law regarding this, which is Ranganaya Kama versus Alvar Shetty. In this case, widow was forced to adopt a boy by her relatives who refused to remove the dead body of her husband for cremation unless she consented to the adoption. So she was forced to adopt that boy because the relatives of this lady said that the body of her husband they will not carry for cremation purposes. So the consent was obtained under coercion. An adoption could not be enforced as there was no free consent. It was affected by coercion. So obstructing a dead body from being removed is an offense under IPC, Indian Penal Code. Now, another example I would like to give you to clarify this concept of coercion. A gives severe beating to B and makes him sign a promissory note for rupees 10,000 in A's favor, which B signs. So it means B's consent is not free here. He has been compelled to, sign that document. Here A has employed coercion by committing an act which is an offense under IPC. Because severe beating, nobody has the right to give severe beating to another person. And if he has given, then it means he has committed offense under IPC. Now, another example I would like to give you. A threatens to kidnap B's son if B does not sell his house to him at a very low price. The consent of B has been obtained by coercion. So friends, B did not want that, his son should be kidnapped. So what he has given his consent. So it means his consent has been caused by coercion or it has been obtained by coercion. So friends, I hope you must be very clear about this concept. I have explained this with the help of case law and I have given you examples also. Now moving ahead friends, the next feature is the unlawful detaining of property or threatening to detain any property. So coercion does not only include committing of the act which is prohibited under IPC or threat is given to commit the act which is prohibited under IPC, but it also includes the unlawful detaining of property or threatening to detain any property. So nobody has a right to detain the property of another unlawfully. And if he does it, then in that case, we will say that he has employed coercion. Where a person unlawfully detains or threatens to obtain any property he applies, then this will be taken as the case of coercion. There is an important case law which is known as Muthia versus Muthu Karupa. In this case, an agent refused to hand over the books of accounts of a business to the new agent unless the principal released him from all liabilities. So books of accounts was the property of the principal, and agent did not have the right to detain that property. So the principal had to release deed under the threat because he was given the threat by his agent. So it was held in the court of law that release deed was wordable adoption of the principal. So this is the case where unlawful detaining property was detained unlawfully by the agent and the property belonged to the principal. And this was the case when property was detained unlawfully by the agent and the property belonged to the principal. And now, friends, would like to take up the example where threat is given by one person to another, by one company to another, that if you do not pay this illegal charges, then your property will be detained. A consigner of Delhi consigned goods to B consignee of Mumbai through railways company. The railway company refused to hand over the goods to B at the point of destination unless B paid the company illegal charges. So B was not bound to pay illegal charges, but railway company told B to pay illegal charges. B paid these charges under threat. Held, B was entitled to recover these charges from the railway company. So consigner is the person who consigned goods, and the goods were consigned to B person, consignee. So consigner is the principal and consignee is the agent. So there was coercion which was employed by railway company in this particular example. Now coming to the next point, which is place of coercion. Now, as per explanation which is given under section 15, it is immaterial whether the IPC is or not in force at the place where coercion is employed. Alternatively, we can say it is not necessary that IPC should be applicable at the place where coercion is employed or exercised. Now, I would like to explain this particular point with the help of example. A and B were returning to India by ship. When the ship was passing through high seas, A threatened B to throw him into the seas if he did not sell him his imported watch. B agreed to sell his imported watch under coercion. On reaching Mumbai, B refused to deliver the imported watch to A. A sued B for the breach of contract. Here, A has, in this particular example, A has employed coercion. Therefore, he will not succeed. So at high sea, friends, IPC is not applicable. But coercion was, this is the place where coercion was employed. But it is applicable at the place, Mumbai, where the suit was filed. So you must bear in mind that it is not necessary. The place where coercion is employed, IPC may be in force or may not be in force. Now, fourth point is coercion may be from the party to the agreement or a stranger. So the act of coercion may be exercised either by party to the agreement or a stranger. Stranger means the person who is not a party or a third party. So I'll take up 2-3 examples and I would like to explain. The very first example is A threatens to kill B if he does not sell his Honda City car to him worth ₹7 lakhs for ₹2 lakhs. So the car is worth ₹7 lakhs but A is giving the threat to B to sell it at ₹2 lakh only. Here the coercion is being employed by A upon B person. So here we will say that the contract agreement will become voidable. Another example, in the second example, A threatens to kill B if B does not sell his Honda City car to C at the given price. A threats amounts to coercion even though he is a stranger between B and C. Now A is saying that if B doesn't sell his car to A at this price, that is which is worth ₹7 lakh, but at 2 lakh rupees, then he will kill B person. So A is a stranger because car is to be given by the owner B and it is to be given to C person. So friends, A is a stranger here. So coercion may be employed by a person who may be a party, or it may also be employed by a stranger, the person who is not a party or who is a third party. So the next is coercion may be directed at a party to the agreement or a stranger. Even coercion may be employed by a person who may be a party and against a person who may be a party, or it may be applied or directed against a stranger. The act of coercion may be directed against any person, relative or near or dear ones, and not necessarily against the other party to an agreement. So now I'll take up two examples to explain this. The first example is A threatens to kill B if he does not sell his Honda City car to him. So in this example, coercion is being employed by A, who is a party, and against a person B, who is also a party. So coercion may be employed by a person who is a party and against a person who is also a party to the contract. Second example is A threatens to kill C, B's wife, if B does not sell his Honda City car to A. Now B gives his consent under coercion. Here coercion has been employed by A against stranger. That is, person is not a party to the agreement. And now second last point is intention of the party. So the act of coercion must be done with the intention of causing the other person to enter into an agreement. So the party's intention must be to compel or to force the other person to give his consent. So in all the examples which I have discussed here in this today's class, in all the examples, party's intention was to force the other person to give his or her consent. Now, one example I would like to take up where, party's intention is not to force other person to give his consent. A threatens to take into the possession of B's flat at South Delhi and not to vacate it. Here, A's intention is not to induce B to enter into an agreement. So no coercion has been employed by A. And now the next point is threat to commit suicide. Does it amount to coercion? And this particular question arose in Calcutta case of Purbi Mukherjee versus Vasudev Mukherjee. One committing suicide places himself or herself beyond the reach of the law and necessarily beyond the reach of any punishment too. So friends, an abetment to commit suicide is punishable under section 306 and attempt to commit suicide is punishable under section 309. If a person commits suicide, but most of the cases we find that the person dies, more than 95% of the cases, the person who makes an attempt to commit suicide definitely dies. Very few cases are there, where a person survives. But this attempt to commit suicide is punishable under section 309. An abetment to commit suicide is punishable under section 306. Now, abetment to commit suicide, friends, here is if sometime we hear or read in the newspaper or watch on the TV that a girl has been sexually harassed. The sexual harassment is too much. Now, one day, what happens? The girl takes this drastic step of committing suicide. Or, over and above this, dowry, in dowry demand cases also, bride takes this drastic step of committing suicide. Yes, she may have committed suicide, but, she has been forced to commit suicide. So this is known as abetment. An abetment to commit suicide is punishable under section 306 of the Act. So the term any act forbidden by Indian Penal Code is wider than the term punishable by the Penal Code. Simply because a man escapes punishment, it does not follow that the act is not forbidden by the Indian Penal Code. And now I would like to take a very important case, which is Chikkam Amiraju versus Chikkam SUSHMA. In this famous case, a husband held out to be a threat of suicide to his wife. He gave the threat to his wife and son that if he would commit suicide if they did not execute release deed with regard to certain property in favor of his brothers who claimed the property as their own. So the wife and son executed a release deed in consequence of that threat. So wife and son agreed because no wife would like that husband to die or son would like father to die. So they agreed and they executed a release deed as told by the husband or father. Held the consent was obtained under coercion and the release deed was voidable at the option of wife and son. So we can conclude, friends, that a threat to commit suicide amounts to coercion. And now coming to the last point, which is threat to file a suit on a false charge amounts to coercion. If somebody gives the threat to other, say that creditor has given the threat to debtor, that if you do not make me the payment on the due date or after the due date is over, but debtor has not made the payment to creditor. Creditor says he gives him 2-3 days extra. And he says, if you do not make me the payment now on the last day of the third day, then I will file a suit against you. Then this threat, which is being given by the creditor to the debtor to file a suit against him, will not amount to coercion. Because this is his right, which he would like to exercise. This is not coercion. But if the false charge is leveled against the debtor, against someone, and then the person gives a threat, the person has not committed crime, he has not done anything, but is made to admit, then of course, friends, that will amount to coercion. So now, friends, I have explained all the features, all 7 features of the term coercion. In the very beginning, I took up the meaning of the term consent. And then I defined free consent, which is given under section 14. Then I gave you the definition of the term coercion. And then I explained all 7 features of the term coercion with the case laws. 2 important case laws I have discussed. One was Ranganaya Kama versus Alvar Shetty, and another was Muthia versus Karupan, and the third was Chikkam Amiraju versus Chikkam SUSHMA. This is all about the features of coercion, and now I will take up effect of coercion. What is the impact of coercion? What is the effect of coercion? Or we can say the consequences of coercion. 3 points I would like to discuss here. The very first point is contract becomes voidable, which you all know. I've told you in the very beginning. In case there is no free consent, then the contract becomes voidable. It becomes enforceable at the option of injured party whose consent was not free one. Then burden of proof. Who has to prove that this party's consent was not free? The burden of proof that the consent of the party was obtained by coercion, it lies on the party who wants to set aside the contract on the plea or on the basis of coercion. A threatens to shoot B if he does not sell his motorbike worth rupees 1 lakh for rupees 60,000. Here B's consent has been obtained by coercion. So the burden of proof will lie with B because B has to prove that his consent was not free one, it was obtained by coercion. Now the second impact is principle of equitable restitution applies in the case of coercion, but it applies in 2 cases. First is where aggrieved party opts to award the contract. Then only aggrieved party has the right to put an end to the contract. Here in this case, if B has decided to award the contract, he is not going to sell his motorbike at a lower price in the above example. Then in that case, it becomes the duty of A has paid, say 50,000 advance to B person. Then B must return this advance to A person. Restitution is to restore the benefit to the person from whom the benefit has been derived. If B is not going to sell his motorbike to A, then whatever benefit he has derived, it becomes his duty, he must return it to A. And the second point I would like to discuss here, Section 72 lays down that a person to whom anything has been delivered or money paid under coercion must return or repay it. So anybody to whom the goods have been delivered or money has been paid or goods have been delivered under coercion, it becomes his duty that he must return or repay it. I would like to repeat that particular railway company case. In that case, the goods were detained by the railway company. An illegal amount of charges was paid by the consignee. So it was a duty of the railway company to return this benefit to the person, to the consignee person, because railway company derived this benefit from consignee person. Now the third point is valid contract. Contract is valid when the aggrieved party, injured party, does not opt to set aside the contract. In other words, we can say the injured party affirms the contract. So there are three points which I've discussed regarding this impact of coercion. First was portable contract, second was restitution, and the third point was valid contract. So friends, it is all about from my side today under this chapter number 5, free consent. Thank you. Thanks everyone. Friends, I hope you will like the content. Do like my videos, do subscribe to my channel, do press on the bell icon so that you can get notifications of my future videos. Okay friends, goodbye. Stay blessed always.